update on new disciplinary procedures, and that'll be presented by our council.
So I just wanted to take this time, there have been a lot of questions about the board's proposed, well, they're enacted now, the last set of proposed changes that the board considered and voted on in September. Those rule changes went into effect 5 days ago on November 30th. And one of the significant changes were the disciplinary process under Part 1 of the board's rules. Over the years, I personally had heard directly and from other people that there was a lot of confusion regarding the disciplinary process with how the board reviews and takes action on officer certifications. So with the assistance of talking with a number of folks, we came up with some revisions to the process that maintained the individual nature of this board. It's unique in the sense that it's the process it follows is different than the other licensing boards in the state, other professional licensing boards. So the rule changes do still reflect the autonomy that's given to the board's director when reviewing the process, and also some autonomy that is also granted to the hearing officers and how they review. So I just wanted to briefly go over the process and stand for any questions if the board has any. Any LEA 90s received as of November 30th will go through this process. There are new time requirements that the board can actually comply with. There were issues in the past that were raised on appeal that were just unworkable with the board meeting 4 times a year. Deadlines that, decisions had to be made within a certain amount of time, and that could not easily line up with the board's meeting schedules and things like that. We will not have that issue any longer with these changes. So just to brief, I won't go read through all of this word for word, but I'll go through the process briefly. What used to be called the board's notice of contemplated action is now going to be called a notice of investigation. Investigation is a term that's used not exactly in the literal sense because the board does not conduct its own investigations. But basically what would happen is when the board's, when the academy and the director receives a LEA 90, they would review the matter and determine whether or not they wanted to pursue more information regarding the allegation. So at that point, the director would then, in his discretion, issue a notice of investigation to the officer. The officer would be given the opportunity to respond back either in writing or request an oral response similar to what has been the past practice. Those timelines are more or less the same, but some of them are adjusted to accommodate a little more flexibility and to make sure that the board can satisfy all the requirements and the rules. So if the individual requests an oral response, basically the same deadlines that were provided before in the rules still would apply. From the oral response, the director then would be given he has the discretion in a few different options. The first would be trying to resolve the matter through a proposed early settlement. Any settlement that the director proposes with the individual officer, say a period of suspension for 6 months or 2 years or what have you, would be subject to board review and approval. So the board could reject that. The second option the board director would have is a recommendation to the board to dismiss. The board could either accept that or reject it. If the board rejects the dismissal, then it would be referred for administrative prosecution. And then the third option is the director himself would have the authority to refer the matter for prosecution. And I keep making these references to prosecution. In the past, the director would initiate the disciplinary proceeding by issuing his own notice of contemplated action or the notice of final decision. The problem that we'd experienced is that the director generally is not a practicing attorney and is not a prosecutor of the state, and therefore there was some confusion as to what exactly was the charging document for initiating an administrative prosecution. So now that's changed. It's referred to the Office of the Attorney General, to a different division, the litigation division, and the same prosecutors in the office would draft the charging document. So it would be a clear document. It would lay forth what the allegations are, the specific violations of the board's rules, and also a summary of the facts that they're focusing on. Sometimes we get complaints that have all sorts of information, and it's really important to provide the individual officer proper notice as to exactly what they're charged with. And so that's what the notice of contemplated action will do. That's drafted by the prosecutor. That process, it's within 90 days of being referred, a notice of contemplated action shall be issued unless an extension is agreed upon with the director. So that was somewhat of a compromise. In the past, the prosecutors had no wiggle room with the timelines for prosecution. They were handed a file, and usually within a month they would have to prosecute the case, which just isn't enough time for them to prep an administrative prosecution in most cases. So that allows for them to do their job more effectively. And then generally the rest of the process aligns similarly to how it has been conducted in the past under the prior rules. The board actually has the discretion if it chose to hear cases, but generally these are assigned to a hearing officer who would conduct the hearing, and as an extension of the board would be advised by me or another attorney who represents boards and commissions in our office. The hearing officer would review the matter and mostly be a fact finder. They would make proposed findings. They do not make proposed conclusions. That's up to the board. And then at the end, the board would accept or reject or amend the proposed findings, and then I would draft the order that has the board's final conclusions. So, any question?
Yeah. Wait to the end or now?
Anytime.
So on the formal hearings, we commonly read those reports. That's what you're talking about now. Are those reviewed by an attorney on staff at the AG's office before they go out?
Generally, the issue has been that I've been trying to review them, but I was also waiting for this process to actually sit down and have a formal education session with the hearing officers, just to make sure that we're all on the same page. So they're consistent. So I mean, some of these hearing officers will provide pages and pages of summary, and some provide a paragraph. And then just enumerated findings. What I'd like to try to work towards, which is consistent with the other administrative boards that we work with, is have at most a very short summary, and then most of the findings be enumerated listed findings.
So to point out, I think that's a great thing. I think there needs to be the one selection process for bringing in for the training. But at the end of the day, many of these reports, we just want to know the facts, right? And there's commentary on there about supervisory issues and or departmental leadership that I'm not just going on record as a board member. I don't think that should be in there by the formal hearing officers. Stick to the facts. Get us to the point, what happened, what didn't happen, and then we can make a decision in closed session. But I think you could convey that to that group as you bring them in to train them. And I don't fault them other than the fact that I don't think that's formally been done yet. So I appreciate you doing that.
Well, and I'm glad you brought that up, Chief DeSantis, because I think that the hearing officers have been as confused as others in this process, because all they have received sometimes is the LEA 90, and so as we know, the LEA 90 may include a lot of internal complaints, employment matters that are not under the board's purview, but the hearing officer gets distracted by that, so they don't understand necessarily what they're really looking at. But by having a prosecutor draft the charging document, I think that the hearing officers will get a better idea of really what they're supposed to be looking at, and hopefully, I can't say that that'll eliminate them from looking at things that aren't under the board's rules, but hopefully it'll reduce it.
Well, we want chiefs and sheriffs, we want department leaders to bring these actions forward to the LEA, right? We want to be on the cusp of issues that address officer misconduct. So when they go through the entire process, and for an agency head to then read a report that is ultimately public about someone's opinion on how they ran their agency in a particular investigation is not a good place for us to be. There's probably other avenues we can utilize to take that up. So that's just a point I wanted to make, and I appreciate that, so thank you.
Are there any other questions generally?
Yes, I have some. One is just a comment under number 11, notice of contemplated action. The word days is left out. Evidence you're hearing within 30 days.
Well, I appreciate that. This is just mostly notes for my assistant and the board staff, so I apologize for that, but that was my...
But, I mean, is it 30 minutes? Is it
No,
30
it's definitely
months?
30 days.
I thought it was 30 days.
I noticed, Council, they're very
I'm sorry.
I sent my briefs over to you, so...
Pain in the tuchus.
No, that's okay, I appreciate that.
And under number 25, it says who gets copies of what, and I'm supposing that copies go to the respondent as well, although that's not listed there. Case manager?
Yes.
Okay, all right, and then number 34 talks about the appeal, and the appeal, the board is informed of the appeal or its outcome, right?
Absolutely.
Okay.
So, and the process, this board is different than many licensing boards in the state fall under an act called the Uniform Licensing Act, and that act provides an automatic right to appeal. So they just file a notice of appeal. With this board, the appeals fall under Rule 75, so they actually have to petition, and the district court has to grant the appeal. It's a low bar, most are granted, but they still have to prove that they have satisfied.
My last question has to do with how many case managers do we have?
Right now, Monica is the case manager.
Monica is everything. I want you all to know that Monica is everything. If you look at this list, the case manager has something to do with 75% of the steps that are taken here are taken by the case manager, and we just simply couldn't get by without her. I hope she doesn't get sick.
Well, I just think she might hate me because, so one of the frustrations that I've heard also from people in the process is that there's just not a lot of uniformity.
And she's the key.
And there had been a time, my understanding is that Monica had performed a lot of these duties, but was asked to then step back and have the hearing officers take care of it. But right now, the hearing officers are taking care of things like driving to the post office and sending things via certified mail, calling all the parties to schedule, rooms and all that stuff. And frankly, it's not an efficient use of their time. And we've seen also instances where they can't keep track of things. And it's hard to expect them to. I think, at least in the structure that we have. So I think that this will be obviously a learning experience for everyone, but we're going to try to make sure it works. And this process may change a little bit. The rules itself don't say case manager on everything, but this is just mostly a...
Well, I commend you for having a central person. I just worry about the burnout of that central person because we don't want to lose her because
I worry about that too.
She gets us all together.
Well, the reality behind it is that it's an unfunded mandate to do all this through LEA to a certain extent, and it's about how much manpower we can throw at it. And I've been in positions internally where we've had discussions about can we add another FTE or position to LEA to complement this, and who's going to pay for it, right? It's difficult. I think though what's important is you're setting the groundwork for future administrations, because we've had attorney generals come in here prior to Attorney General Victor Balderas that took absolutely no what's the word I'm looking for?
Interest.
Interest or initiative to help the process. It's never been better now as far as the internal workings of the board and trying to look at things and make them make more sense. So we were kind of feeling our way through the dark for years, and I sat on I was on this board when they transitioned, so I do appreciate your office doing that, and I think keeping in mind that what we're doing here hopefully will just carry over, because too many times a new chair will get seated and you start from the beginning. It's not fair to the public, nor the officers coming before us, so this is a good thing. Thanks.
Thank you.
Yeah, absolutely. Just a couple last points, and then also if there's any other questions. The way the board will review these hearing officer reports, as I explained before, and what is happening now and will continue to happen, is that the board has an opportunity to review the entire record of each of these matters, and it's important that that review take place. One of the issues raised on appeal often is that decisions by the board are arbitrary. The board decisions now, the board orders have conclusions of law, many of them that tie the facts to conclusions that the board is making to support any discipline it takes. So that will always be included in orders. I know that there have not always been that practice in the past. So my hope is that setting a precedent would be helpful with this. The last thing I wanted to just highlight also, although it already was in the rules, it's written more clearly now, is the directive for agencies to report discipline. Instead, there were multiple deadlines depending on whether or not the IA lasted more than a 30-day period, but there was a 90-day deadline. Now it just simply clarifies that any evidence of alleged misconduct, regardless of whether or not there's a final determination, especially in those issues of voluntary resignation in lieu of discipline, which an agency has a right to do, but the rules state that there's an obligation then to still report it to this board. And that timeline is just 90 days. So it just clarifies the process. I think that the board's been concerned that not all have been coming to it, and I think some people have been saying, well, if we don't ever conduct an investigation, we don't have to report it. But the old rule, you could glean that from, but I don't think people could make an argument either way, but now it's clear. It's clear, I think. So, are there any questions? Other questions?
So I'm clear, this is not for dissemination within agencies, this is purely draft at this point in time.
I mean, I don't have necessarily a problem with this. This was made for my use of being able to explain the process first to the LEA staff and also to the prosecutors, but I don't have a problem with it being shared. I certainly, maybe some of the grammatical changes I can fix.
We'll get that input from me, I'll tell you right now. But I think that the director should take note, is the other arm of this is educating the agency heads as to the process so they understand it, right? And I would think something would go out from your office saying, please review this update of the process and rules adopted by the board. That'd be my only, once you're finalized with it, my only wish. So they're tracking also and understand. Because I get a lot of calls as a board member, I don't understand this process, how did it go from here to here to here? And maybe they'll get a better idea. And I think we should actually list it on the website so people can reference it, even the public.
Yes. So one thing I was planning to do was to include in the notice of hearing, which will be a new notice of hearing that's revised a little bit to explain this process, is to put in layman's terms, even if it's an attachment to it, how things work. If there's any preliminary motions, this is how they should be filed. If you need to contact the prosecutor may be contacted this way. I think especially pro se, licensees, officers who aren't represented by an attorney are a little confused with the process. And truthfully, attorneys are just as confused sometimes because administrative law is a small area of law and this process is unique. There's no other board like this in the state. So I'd like to provide a little bit more information. That's the expectation at some point moving forward when we get into the swing of things with these new rules. Okay.
Is it currently, I'm sorry.
No, that's fine.
Is it currently right now that just the agency, only the agency can deal with their own officers as far as sending an LEA 90? Or can one agency file it against an officer from another agency?
The rules are not explicit in that, and I don't know if that's intentional, but I can't speak further than it does not require or prohibit either. So I don't know.
We've had that happen before, where, or even it's pretty broad because you don't want. I think the creation of the process, she didn't want to dissuade anybody from bringing items of attention to the board. We've even had where a chief or sheriff's made a decision in discipline and suspended someone for 40 days and thought it was a done deal, only for a sergeant that didn't agree to send it up to the board. It was kind of an awkward process.
I've also seen, I mean, historically, I've seen a DA
And that's what
file
I've
one.
seen.
I've seen.
So I didn't know if there had been more.
I did not change, I was, when I'm looking at this, and, you know, it was just a recommendation for fixing the process. I was trying to avoid any serious policy changes intentionally. So if there were any, that was not, I mean, I don't think there are. I think it's mostly just procedural, to clarify the process and to make it more clear. So I think that there are many of those more policy-related issues that still could be resolved with these rules. And I think the expectation is with the Rules Committee that this Part 1 will be looked at again. Perhaps some of these more policy-related issues can be addressed and see if the board is interested in making any changes or clarifications.
And the last part was as far as, I know we had to the process for the past couple of years of reducing the officer being able to speak to the board, whether it was the attorney, family, anything like that. I know we reduced it down to him. We've taken it out completely. Is that what I'm understanding on this?
That's correct, and the rules always stated that, so I don't know what the practice necessarily was. And I think the concern from a legal standpoint is that the record is complete, and you start allowing them to testify. I mean, it's one thing to make an emotional summary of their case, but I think the problem then is that they don't necessarily know if they're going to start introducing new evidence, and then the prosecutor then doesn't have an opportunity to object. You're having a whole other hearing. And so, although I mean, there's an argument for that, it's not in there. So.
Okay, thank you.
If I may, just to build upon your point, Chief, the new form and formatting of that form, the LE 90 form that the board approved a couple meetings ago, actually requires the department head signature. Right, so that prevents the sergeant from sending one up that the chief didn't have any understanding of. Or in the case that you're talking about, you know, another agency without that other chief administrative officer having an understanding of the level in any information that's passing forward. So that one small change to the form has definitely helped in that process. At least the chief, you know, of that agency has an understanding of what's occurring.
And I thought one time there was even someone in the public that filed an LEA 90. Are those, is that being recognized at all in any way, or?
If I may, we do receive occasionally public submitted forms that are available on the website. We take a look at them generally, they get referred to the agency for their consideration initially. But we have considered and addressed several that were publicly filed because, again, the forms on the website. So, I'll tell you, in practice, most of them state issues that really don't apply to us because that's why we send them back to the agency. We usually find that if there's something we have control over, most of them are just more broad complaints, so we do receive them on a regular basis. And we do review each other.
And I know there's been educational efforts in trying to explain to the departments that employment matters that don't fall under you know, the purview of the board shouldn't be referred. I don't know if there's been a reduction in that or not yet.
So Brian, just last question for DA referral, LEA 90, did we specifically discuss that in changing the form, that the policy was to not encourage that? Was that the intent of the board in doing that?
No, sir, I don't believe so. I don't believe so. It's just, you know, the chief administrative, you know, officer of that organization, be it the DA's office, the DA themselves being the chief administrative officer of that. That's what I was trying to encourage. That's all it was.
I think if one of your ADAs had sent up the form, LEA would look at it and say, well, you know, we need to make a phone call to make sure that the actual DA knows about it. It might have been on your site, or you might say, I have no idea. I'd like to see that before it goes up. So it's good.
Thank you.
Any more questions? Thank you. That concludes item number 12. Thank you, Joe.
Mr. Chairman,